This is case number 20000196, Robert Davis versus Jocelyn Benson in her official capacity as the duly elected Michigan Secretary of State. If you would please bring counsel into the hearing room. Or more accurately, counsel and the parties. Mr. Davis, we do not yet see you.
Your Honor, I'm appearing by audio, Your Honor. Can you hear me?
I can. Okay. This is a hearing on a complaint for declaratory judgment. On October 15th, after service of the initial complaint and the day before this hearing, the court received something which says it's an amended verified complaint for declaratory judgment. I would ask first that parties state their appearances for the record so that the court reporter may have them. And then I would like to ask Mr. Gill if he received this amended verified complaint. Please state your appearances on behalf of the plaintiff.
Good afternoon, Your Honor. May it please this honorable court, Robert Davis, pro se plaintiff.
On behalf of the defendant, please.
Sorry, Your Honor. Good afternoon. This is Eric Grill, Assistant Attorney General, appearing on behalf of Secretary.
And Mr. Grill, did you receive an amended verified complaint for declaratory judgment?
Excuse me, Your Honor. I'm sorry, I was on mute. I am checking right now, Your Honor. I believe we did. You know what, Your Honor? My folder here, Your Honor, does not show an amended complaint. We've received a number of amended complaints from Mr. Davis, but I don't appear to have this one.
Mr. Davis, would you please address the issue of filing an amended complaint a day before the hearing?
Yes, Your Honor. The amended complaint was served via email upon counsel for the defendant, Jocelyn Benson. The amended complaint was timely filed in accordance with the Michigan court rules, which simply added the FOIA violation count. Mr. Grill was included on that email, which was also included with the filing with the court. So the court clerk will clearly indicate that Mr. Grill was included on the email when the amended complaint was filed with the court.
Mr. Davis, what I will tell you is, as far as I'm concerned, the amended complaint is not before me because it was filed yesterday. And that would not be a timely filing for the purposes of a hearing that was scheduled today.
Yes, Your Honor.
So if you would proceed as to your prayer for relief on the original complaint.
Yes, Your Honor. Just for the record, the count 1, which is the subject of the hearing today for the emergency motion for declaratory judgment, was not changed in the amended complaint. The amended complaint just simply added the FOIA violation count, just for the record, so that the merits of the motion being heard today can proceed, Your Honor, because no facts were changed in the amended complaint with respect to this count. The prayer for relief, Your Honor, is very simple. The written directive issued by the Secretary of State in an effort to have this court's order issued in another matter applied statewide is a rule under the Administrative Procedures Act. And consequently, Your Honor, the rule has to be promulgated in accordance with the Administrative Procedures Act. The written directive that the Secretary of State issued in an attempt to try to have this court's order binding all local clerks was a rule that has to be promulgated in accordance with the APA. It was not. For the Secretary of State to try to assert the argument that this argument is frivolous or absurd clearly indicates that the Secretary of State does not read the law and is simply trying to unilaterally make rules without following them. There is no argument made by the Secretary of State addressing the merits put forth in the original complaint and in the motion and the subsequent reply brief, Your Honor. This legal issue is meritorious. Legal issue is very clear. The written directive is a rule by definition under the Administrative Procedure Act. And I believe that the legal arguments put forth in the brief and in the reply brief make that very clear for the record.
Mr. Grill.
Thank you, Your Honor. Respectfully, Mr. Davis's arguments are simply incorrect. The premise here that the injunction this court entered in the Michigan Alliance case was not binding on the clerks simply doesn't hold water. If that were true, number one, the injunction was the injunction of the statute. It didn't enjoin the secretary from taking particular actions. It enjoined the enforcement of the statute, which applies to everyone. Further, since the local clerks are the ones that actually receive the absent voter ballot, if that were not in any way effective upon the clerks, then this court's injunction was effectively meaningless. We don't really get to that point, though, because Mr. Davis looks Section 31 of the Michigan election law, which provides that the Secretary of State has the following duties. First, under Section 31, sub 1, sub A, the Secretary may issue instructions and promulgate rules. As this court's well aware, it's a well-established principle of statutory construction that we don't read statutes and interpret them to be surplus or nugatory. The legislature has expressly provided for both the issuance of instructions and the promulgation of rules. So those are two separate, distinct things. In addition, Section B of Section 31 also provides the Secretary has the authority to advise and direct the local election officials on proper methods of conducting elections. When the Court of Claims issues an injunction directly affecting the enforceability of a portion of the Michigan election law, it is certainly within the Secretary's authority to advise and direct the local clerks as to what to do now in the face of that injunction. And that doesn't require the promulgation of any rule. That's essentially the nutshell of it, Your Honor. The rest of the matter, I think, is addressed pretty well in our brief. I would also touch briefly on the fact that we have raised a frivolity and a issue in this case. I'm sure the court can detect our frustration, and I think the court understands why. Certainly, Mr. Davis knows very well what an injunction is. He's asked for several already this year. And I would invite the court to ask whether Mr. Davis, whether in one of the lawsuits he's filed in front of the federal court, in front of Judge Lightman, which he has asked a portion of the Michigan campaign finance law to be enjoined, whether Mr. Davis believes that that requires the promulgation of a rule. And if he does not, then I cannot for the life of me understand how he would believe that this motion or this complaint was founded on fact or law that would warrant relief in this case.
Anything finally, Mr. Davis?
Thank you, Your Honor. I think Mr. Grill once again is truly ignoring the clear language of the Administrative Procedure Act of the definition of what a rule constitutes. The Secretary of State's written directive to the local clerks was necessary because this court's order in the Michigan Alliance case was not binding upon the local clerks. Hence the reason why the Secretary of State found it necessary to issue the written directive to the local clerks. The local clerks do not fall within the jurisdiction of the Court of Claims. Thus, any order issued by the Court of Claims with respect to the Attorney General and the Secretary of State was not binding on the local clerks. The only way that the Secretary of State could have applied this court's order to the local clerks is by issuing the written directive. The written directive, by definition, under the rules of the Administrative Procedures Act, is a rule. Very clear. Although Mr. Grill and the Secretary of State have found it convenient to ignore certain sections of certain provisions of the law for their own personal political agendas, It does not circumvent the clear language of the Administrative Procedures Act and the definition of what constitutes a rule. The written directive or instruction or guidance provided by the Secretary of State to the local clerks, by definition, was a
Mr.
rule.
Davis?
Yes, Your Honor, not to repeat myself.
Yeah, that's kind of what you're doing. Is there anything new you wanted to share?
No, Your Honor, I think the brief and the reply brief, for the record, did you receive the reply brief that was filed about an hour prior to this hearing?
Of course I haven't. Mr. Davis, filing things an hour before a hearing is at best presumptuous.
I would agree, Your Honor.
Okay, the court will take this matter under advisement and you will get an order Monday morning. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.